Welcome, everyone, and thank you for joining Pay to Play Indigent Defense in Harris County. We're delighted to be joined by several key partners as we explore the critical question of how judicial campaign donations might influence the appointment of defense counsel in our criminal courts. During today's session, we'll hear from our project partners about their involvement, share our key findings, demonstrate the interactive dashboard, and provide actionable recommendations on how you can help address these systemic issues. This project represents a collaborative effort that wouldn't have been possible without the vision and support of several key stakeholders. We're absolutely grateful for the inspiration from Commissioner Rodney Ellis, the leadership from Dr. J and the Texas Commission for Justice and Equity, the guidance from Urban Institute, and the generous funding support from Microsoft. At this point, I'd like to invite Sophie Elsner from Commissioner Ellis's office to share a few words.
Good afternoon. Thank you so much. So first of all, thank you to January Advisors for hosting this important discussion on judicial appointments for indigent defense. And on behalf of Commissioner Ellis, who was fortunately unable to attend at the last minute, we really appreciate being included. It's fitting that we're holding this webinar on National Public Defender Day, which falls on the 62nd anniversary of the landmark Supreme Court decision of Gideon versus Wainwright, which held that you could not have a fair trial without counsel. Ensuring that every person, regardless of income, has access to quality legal representation is fundamental to a fair criminal legal system. Yet, over 60 years after that Supreme Court decision, we must still fight for equal justice under law. Harris County has made significant strides in strengthening our indigent defense system over the past 15 years. In 2010, Commissioner Ellis advocated for the creation of a public defender's office for Harris County. And since then, we've expanded the public defender office to house over 130 dedicated attorneys. But despite this growth, most people who cannot afford legal representation in Harris County are assigned a private attorney, not a public defender. 85% of the cases in felony courts, which hear the most serious allegations and which we'll talk about today, are represented by appointed private attorneys who are subject to zero attorney oversight. Attorneys answer only to the judge and the court where the case will be assigned. And contrary to the American Bar Association's #1 core principle for public defense, which is the independence from the judiciary is still responsible for 85% of indigent felony case appointments in this county. Year after year, we have learned how flawed this system is. Many of these attorneys make hundreds of thousands of dollars each year representing indigent clients. And in 2022, one attorney made over $1 million on indigent representation alone, and 7 others made over $500,000. We've also seen that these attorneys habitually carry caseloads that are 2 to 5 times above the guidance from the Texas Indigent Defense Commission. In several cases, there were clients who did not receive a single visit from the attorney appointed to represent them. And the pay-to-play study presented very clearly the undeniable existence of a quid pro quo between these attorneys and the judges who appoint them, which can really come at the expense of the accused. So that brings us to today. In 2020, right after the murder of George Floyd and on the day of his funeral, the Harris County Commissioner's Court passed a series of justice reform efforts, including a directive to the Public Defender's Office to develop a plan to increase its capacity so that it could take on at least half of indigent defense case appointments. The progress toward the goal has been slow and challenging, and Commissioner Ellis and Commissioner Briones created the Indigent Defense Committee in 2023 to help develop a plan to fulfill this goal. At that time, Commissioner Ellis also recommended the creation of a public-facing dashboard showing the data behind the privately appointed counsel system. So we'd like to thank the Texas Center for Justice and Equity and January Advisors for hearing this call, understanding the need to publicize this information, and following through with an excellent product, which that's what we'll be looking at today. We must move toward an independent system of appointments to ensure fairness and accountability. I'm sure we'll talk more about that at the end. And that starts with ensuring the public defender's office provides quality representation and can increase its scale, but it doesn't stop there. On behalf of Commissioner Ellis, I appreciate the opportunity to speak with you all today, and we are so excited to be working with our judges, attorneys, and community stakeholders like all of you to build a more just and equitable system for all. Thank you.
Thank you, Sophie. I appreciate that. And thank you to Commissioner Ellis for his leadership on this topic. Now I'd like to welcome Dr. Karen Johnson of the Texas Center for Justice and Equity. Dr. J.
Thank you, Jeff. Thank you, Sophie. Good afternoon, good day, wherever you may be joining us today. I am Dr. Karen Johnson, go by Dr. J. I'm a queen of African, Blackfoot, Cherokee, Japanese, Jewish, and Seminole descent. As an over 40 heterosexual woman of faith who believes that gender-inclusive language is very important, I do charge a virtual quarter for the virtual kitty anytime anyone says you guys in the presence of anyone who identifies as she, her. Now, I became the executive director for the Texas Center for Justice and Equity in May 2024, and shortly thereafter met Jeff when many of the leadership changes were going on, a lot of staffing changes was going on, and he was talking about this indigent defense dashboard. And the question posed to me almost, I don't know, not even 30 days into the job is, do we want to move forward with the work? And my answer, not knowing anything except for the mission of TCJE, which is to advance solutions and build coalitions to end mass incarceration, my answer was absolutely yes. And why would that be? Well, it's because Brian Stevenson, who is the lead or the head of the Equal Justice Initiative, wrote in his book Just Mercy that quote, that capital punishment means that you are punished if you don't have the capital, end quote. And so I definitely wanted to find out what was going on in Harris County. I learned that Jay Jenkins, who was a former member of TCJE, who I did not have the pleasure to meet, was actually the one who heard the cry that Commissioner Ellis put forth that Sophie just mentioned. And this is why today's webinar on pay to play indigent defense in Harris County is so important to the Texas Center for Justice and Equity. When we think about judicial campaign contributions and mass incarceration, the practice of judges receiving campaign contributions from lawyers to whom they later assign cases raises serious ethical and systemic concerns about the judicial impartiality in Texas and beyond. This pay-to-play behavior contributes to the entrenchment of mass incarceration by creating or potentially reinforcing biases in judicial decision-making that favor punitive measures over fair and restorative justice, thus undermining fair legal representation. So for us at TCJE, transforming or eliminating judicial campaign financing, strengthening ethical standards and accountability, and supporting restorative justice measures are really essential steps toward creating a more impartial and just legal system where every person has the opportunity to succeed. Thank you all. Thank you, Jeff. Thank you, Amar Urban Institute. Thank you, Precinct 1, for this incredible work. And I'm looking forward to hearing more today about what it is that we did discover through your work at January Advisors. Back to you, Jeff.
Thank you, Dr. J. I appreciate that. Next, we're going to hear from Amar Khalid from the Urban Institute.
Wonderful. Thanks. Thanks so much, Jeff. And yeah, thank you for the invite. It's great to be joining today for this important, timely conversation. I'm Amar Khalid. I'm a senior policy associate in the Urban Institute's Justice and Safety Division. And together with my colleague, Sam Bachman, who's a research assistant on our team, over the last few months, we provided project assistance to the Texas Center for Justice and Equity and January Advisors team. We had the Microsoft Catalyst grant program. But before I go over what the grant program kind of entails, let me just provide a brief overview of the Urban Institute for those who are not familiar. Urban Institute is a nonpartisan, nonprofit, independent research organization. We work to inform policy and practice by providing data and evidence to change makers across the political spectrum at the local, state, and federal levels. Within the Institute, my colleague Sam and I, we sit in the Justice and Safety Division, which conducts research and policy analysis to support criminal legal system actors and community members regarding all aspects of the criminal legal system, including criminal court processes and actors. And particularly related to today's topic, recently we've done work on innovations in defense, judicial decision making, and prosecutorial discretion. Next slide, please. So the Microsoft Catalyst Grant Program, this is really a collaboration between Microsoft and the Urban Institute. The main aims of the grant program are to, one, help nonprofit organizations use data and technology to advance racial equity in the adult criminal legal system, to build the capacity of these organizations to use tech and data even beyond the grant period, and third, share innovations and lessons widely so organizations in other places can learn from grantee experiences as well. The focus for the grant program is really on projects that aim to kind of help prevent unnecessary legal system involvement, decrease racial and ethnic disparities in the front end of the criminal legal system. And so the program has been in place since 2021, and about 91 locally embedded organizations from across the country have been funded thus far, one of which is the team of Texas TCJE and January Advisors. And yeah, it's been great to work with them over the last few months. We've learned a lot from them, and we're excited to kind of see their efforts come to fruition. And really, just last thing I'll say that this is the sort of work and the sort of connotations that we're looking to foster through the Catalyst Grant Program. So thanks so much for having us and for this opportunity.
Thank you, Amar.
Thank you.
All right, before we dive into our findings, I also want to acknowledge that this project builds upon groundbreaking work conducted by Jay Jenkins of the Wren Collective, formerly of the Texas Criminal Justice Coalition. Jay's initial research in 2019 and 2020 established the foundation for our current analysis, and as Sophie mentioned, it brought this critical issue to the attention of Commissioner's Court and Commissioner Rodney Ellis. And so I want to recognize all the hard work that Jay put into this long before we ever came around. I also want to recognize Brian Barr from our team, who serves as our resident criminal court data expert. Brian was the primary data analyst for this project, and he worked day and night to ensure the accuracy and integrity of our findings that we get to share with you here today. So let's talk about our central research question. The central question driving our research here is straightforward but profound. Do campaign contributions influence who receives case assignments in Harris County's criminal courts? In other words, are political donors effectively being repaid through the assignment of casework? To understand our findings, it's important to first understand how indigent defense operates in Harris County. And Sophie had mentioned a little bit of this before, and I'm just going to restate it. When someone facing felony charges cannot afford an attorney, they will either receive representation through the public defender's office or have an attorney appointed by the judge overseeing their case. Now, 5 out of every 6 indigent defendants have a judge appoint their attorney rather than getting representation from the public defender's office. Last year, that meant that over 25,000 felony cases were handled by appointed attorneys. As a result, there are significant financial implications with very little oversight. And that's precisely what Jay Jenkins and Georgetown Law uncovered in their 2020 investigation. At minimum, the current system creates an appearance of impropriety and potential corruption. With minimal oversight, some attorneys have managed to secure hundreds of cases from specific courtrooms, resulting in annual earnings that can reach hundreds of thousands of dollars. For attorneys managing such high caseloads, it becomes difficult to believe that they can adhere to best practices and provide quality representation for each client. This raises serious questions about the quality of justice being administered and the fairness of our criminal legal system. From here, I'm going to hand it over to my colleague, Dr. David McClendon, to take us through some of the analysis and findings.
Thanks, Jeff. Hi, everybody. My name is David McClendon, and I lead our data and research team here at January Advisors. I'm going to take us through the data and methodology of what we did, share some of the key findings, and then walk you through the dashboard that we built. So for this project, we relied on two primary data sources. The first is campaign donations from the Texas Ethics Commission, which includes all donations made to district court judges in Harris County in 2024. It's important to note that we only analyzed judges who were in office in 2024, and our data collection took place in August before the most recent November election. The second source is Harris County District Court criminal case data, specifically cases filed between 2017 and 2024. Now, linking these two data sets isn't as straightforward as you might think it would be. One of the biggest challenges was, matching the campaign finance data, which is filed as individual PDFs every quarter, to the attorneys who serve as court-appointed counsel in the criminal court data. That first meant that we had to go through and clean hundreds of documents to create a structured data set that could be analyzed. And next, we had to actually, do the matching of attorney names across different data sets. But as you might imagine, people spell their names differently, use abbreviations or honorifics like junior or senior in one data set and not in the other. So to account for this, we had to use a mix of different matching methods as well as some manual verification. And despite our best efforts, there may still be a few incorrect matches of people with the same name, for example. But the overall trends remain pretty clear. Once we had a fully matched data set of donations and appointed attorneys, we focused on cases where indigent defendants were assigned court-appointed counsel. Then we analyzed which judges were appointing donor attorneys, how frequently, and what impact this had on case outcomes. One of the first things we found was just how much money flows between indigent defense attorneys and the judges who appoint them. So as of 2024, Harris County District Court judges on the bench had received over 1.2 million in campaign donations over the course of their careers from attorneys who had served as appointed counsel for indigent defendants. That number, of course, doesn't include all the other donations they received. This is just focusing on those defense attorneys who received case appointments. Moreover, this wasn't limited to a handful of judges. So 25 out of 26 judges received donations from attorneys who regularly appear in their courts. So this chart on the right shows the range of the total donations judges have received over the course of their career. Some raised a few $1,000s from a small group of donors, while others collected over $150,000 from dozens of contributors. So naturally, we wanted to understand whether these donations influence judicial appointments. So are campaign donors more likely to receive court-appointed cases than non-donors? To answer this, we developed a donor preference index, is what we're calling it. So this is a metric that measures how much more likely a judge is to assign cases to a donor compared to if the assignments were random. So a donor preference index of 1 would mean that donors and non-donors receive appointments at roughly the same rate as their overall presence in the active attorney pool. An index of 2 means donors are twice as likely to receive cases, and an index of 3 means they're 3 times as likely. So across all courtrooms in Harris County, before we dive into specific courtrooms, we see that here on the left, so there 15% of cases were assigned to donor attorneys. But the 15% were assigned to them, but the donors who donated only represented 7% of active attorneys. So we use these two numbers to calculate the overall donor preference. So by dividing these two numbers, we see that overall judges were 2 times as likely to assign an indigent defense case to an attorney who's a donor than if the assignments were random. And as Sophie and Jeff outlined, more cases equals more money for defense attorneys, and that's what we mean by pay to play. We also found that attorneys don't necessarily have to spend large sums of money to see a return. The average donation from an indigent defense attorney was just $800. This is not a massive amount of money, but it was enough to make a difference in how often they received case appointments. This chart on the right shows that more donations equals more cases on average. So the x-axis here is groups attorney-judge pairs, which are these little dots, based on the total donated amount. So from the lowest tier on the left to the highest amount on the right. And the y-axis represents the total number of cases assigned to that attorney by the judge. So while there's lots of variation, the average pattern is pretty clear. Donors who contribute more money get more cases on average. Now let's take a look at how this plays out across individual judges. So in this chart, each judge is represented by a bar that shows their donor preference index in 2024. So the majority of judges down near the bottom, they show some preference for donors. So a lot are in the sort of 1 to 2 range for a donor preference index, meaning that donor attorneys were 1 or 2 times more likely to receive a case than at random. But as we move up the chart, we see some judges with much higher donor preference indexes. So a handful have values between 3 and even upwards of 8, showing us a much stronger preference for appointing donor attorneys. And then there's one extreme outlier here of a donor preference index of 21, which is in part due to just low numbers of donors and low numbers of assignments, but also has to do with the fact this is the first year on the bench too for this particular judge. So it's unclear what's going to happen going forward. So how does this system impact defendants in terms of case outcomes? A common argument for defenders of this system is that perhaps donor attorneys are simply better attorneys. They're more experienced, they're more effective, or more respected, and they have, for those reasons, they have more money and they donate to these judges. So if that were true, then indigent defendants might actually benefit from being assigned to donor attorneys. But that is not what we see. This chart on the right compares case outcomes between donor attorneys in red and non-donor attorneys here in the dark gray. So as you can see, the results are almost identical. So donor attorneys and non-donor attorneys have similar conviction rates here. They have similar dismissal rates, similar deferred adjudication rates, as well as a similar share of cases in which defendants plead down. But an interesting thing to note is that the white bars here represent the cases handled by public defenders. And that's where we see a big difference. So public defenders consistently secure better outcomes for indigent defendants with fewer convictions and more dismissals compared to donor and non-donor appointed attorneys. So that's at the aggregate. So we've seen that donor attorneys receive more case appointments and they don't necessarily achieve better outcomes for their clients than non-donor attorneys, and especially not compared to public defenders. But when we break things down by judge, we start to see some differences and some troubling patterns that highlight why it's important to analyze this data courtroom by courtroom. So in this chart, we're looking at the percentage of cases where defendants pled down, and we're comparing donor attorneys, the share of cases pled down among donor attorneys and non-donor attorneys. So each line here represents a courtroom. So if donor attorneys and non-donor attorneys were securing similar plea outcomes for their clients, we'd expect these lines to be roughly horizontal across the board. And in most courtrooms, that's what we see here in the middle. So the difference between donor and non-donor attorneys is fairly small. But there is one courtroom here that stands out. In this particular courtroom, cases handled by donor attorneys were twice as likely to end in a plea deal compared to cases handled by non-donor attorneys. And it's a pretty significant gap. Now, a plea deal isn't always a bad thing. It can sometimes be a strategic decision that benefits a defendant. But in this case, the difference is large enough to raise questions. Why are donor attorneys in this courtroom securing plea deals at twice the rate of non-donor attorneys? Is this a reflection of judicial discretion? Are donor attorneys receiving different types of cases, or is something else at play? And this is where our dashboard really becomes valuable. Because rather than just looking at system-wide patterns, the dashboard lets us zoom in on individual judges and courtrooms to better understand these dynamics. And before we go on, and I give you all a tour of the app, I want to highlight something important and some potential good news, and that is that judges can change their behavior. So this next chart looks at how donor preference has changed over time among individual judges, which are represented here by each line. So some judges, we can see here on the left, are increasing their donor preference index over time, which means that they're getting more and more likely to assign cases to donor attorneys at quite high levels. A lot of judges are sort of what we looked at where they have low donor preference index, and that stayed relatively stable over time. But what's interesting is that some judges who initially and over the course of their careers have shown a strong preference for donor attorneys, many of them have actually started reducing their reliance on donors. So a few years ago, these judges were high on the donor preference index, but over time they've shifted downward, closer to 1, closer to that kind of even at random number we're hoping for, and appointing a more balanced mix of donor and non-donor attorneys. And this suggests that judicial behavior isn't set in stone. So some judges are adjusting their approach, and whether that's due to public scrutiny or internal decisions or other factors. And it's an important takeaway from this research is that greater transparency has the potential to lead to meaningful changes in the system. So now that we've covered the key findings, I'm going to switch tabs here, and we're going to take a look at the dashboard itself. So this tool is designed to make the data more accessible and transparent and allow you and the public to explore judicial appointments, donor influence, and case outcomes across district courts. So when you first open the dashboard, you'll land on the home page, which provides, again, a lot of the high-level summary I've gone over here in terms of a data story about some of the key findings that we found. Further down, you'll find the judicial overview table, which this provides a side-by-side comparison of all district court judges in Harris County. This table is sorted by donor preference index here on the right. So the judges with the strongest preference for donors are at the top. On the left, you'll see how many indigent defendant attorneys have donated to each judge's campaign. So for some, it's a handful. Others have upwards of over 100 different donors. And moving to the right, you'll see the total amount of donations here, as well as the average donated by attorneys. And then we'll see the two numbers that make up the donor preference index. So the percentage of cases that were assigned to donors, as well as the percent of active attorneys who are donors. So again, dividing these two numbers gets us this donor preference index. So now that we've gone through this table, let's take a closer look at one judge in particular, Judge Nikita Harmon, because better illustrates both the functionality of this and what some of the patterns that are play out at the court level. So one of the reasons I wanted to choose this was she does have one of the highest donor preference indexes here of nearly 8 in 2024. And we also see that, while only her donors represent 9% of all active attorneys, she assigns cases to those donors in 74% of cases. So let's take, to look at a particular judge, you just need to click on their name, and then it takes you to the judge profile page up here. So the profile here, again, you can switch judges here, looking from this dropdown, but also see some of the key stats, like number of defense attorneys, percentage of cases assigned to donors, that we saw in this front table. We also get to see what the donor preference index looks like over time. And again, we have the comparison here of, if it was at random, it would be 1. Judge Harmon has been above that since the start of her career in 2017, in which the donor preference index was 2.9, so donors are almost 3 times as likely to receive cases, and has been steadily increasing over time up to 8 in 2024. Now, if we scroll down, we get to answer some other key questions here. So, for instance, what types of cases are donor attorneys receiving in this courtroom? So the first thing that jumps out on this left table is that in Judge Harmon's courtroom, 32% of cases assigned to donor attorneys are assault cases here, while only just 25% of cases assigned to non-donor attorneys are. So this suggests that donors may be receiving a disproportionate share of assault cases in certain types of cases, which raises some important questions about how cases are assigned and whether these patterns are intentional or not. Another important factor that we allow users to look at on the dashboard deals with defendant race. So we know from broader research that Black defendants are overrepresented in Harris County's criminal court system, whether they're indigent defendants or not. And this chart just compares the racial composition of donor attorney caseloads versus non-donor attorney caseloads among these cases who have appointed counsel. So we see that 54% of cases handled by donor attorneys involve Black defendants, and this is race assigned in the criminal court data. And so 54% versus 50% among non-donor attorneys. This difference isn't huge, but it does suggest that in this courtroom, Black defendants may be disproportionately impacted by the donor-based appointment patterns that we see. Now let's move down to the case outcomes. So this section of the dashboard lets us compare results that donor attorneys achieve for their clients versus non-donor attorneys. Looking at this chart, we see in Judge Harmon's courtroom, donor attorneys actually achieve slightly worse outcomes on average than non-donor attorneys. So we see slightly higher conviction rates, we see and lower dismissal rates for donor attorneys. We also see that plea downs are somewhat higher for donor attorneys than for non-donor attorneys. We can also filter this section by case types. So right now we're looking at all case types, but we could, for instance, look at assault cases that we were talking about earlier. And here we see an interesting pattern. So donor attorneys in this court are slightly more likely to secure a deferred adjudication than non-donors, which means that their clients often avoid conviction, but still potentially have to go through probation. However, donor attorneys are less likely to secure outright dismissals, meaning their clients are still more likely to face some form of legal consequence and justice involvement than in having their charges dropped entirely. So while donor attorneys may help keep cases out of trial and avoid convictions through deferred adjudication, they don't necessarily achieve the best outcomes for their clients in this case. We also on the right-hand side here show the time to disposition. So this compares in red and in black here the median time to disposition between donor attorneys and non-donor attorneys. So in this particular, for assault cases, we see that donor attorneys generally resolve more quickly than non-donor cases. And, in some cases, some situations, a faster case resolution could be a good thing, particularly if defendants are spending less time in jail before trial. However, if those faster resolutions are driven by deferred adjudication or plea bargains rather than dismissals, it can raise some concerns about whether indigent defendants are being pressured into quick deals rather than receiving full legal defense that they deserve. In this last section, this page lets you look at more of the raw data and allows you to see every indigent defense attorney who's donated to this judge's campaign throughout the course of their career. It also has details about the amount that they've donated, the date of the contribution, as well as whether they were ever appointed by this particular judge. So this is where you can really start to see the direct connections between campaign contributions and case appointments. So in addition, you can look up for a specific attorney here, and also look at some of the timing between when they donated these as well. Finally, I want to just show you real quick that you can how to easily switch between. Let's take a look at another judge, Josh Hill, that shows a little bit of a different pattern. So unlike the previous court we looked at, Judge Hill has a much lower donor preference index throughout the course of his career, meaning he assigns cases more evenly between donor and non-donor attorneys. However, he does have a lot of donors. 24% of active indigent defense attorneys have donated to his campaign, but he only assigns 32% of his cases to donors. So it's a much smaller gap. And what's notable is that this has been declining over time, the course of his career. So when he first took the bench, it was almost 2, donor preference index of 2, 1.8, and now is more to 1.3, one of the lowest we see in 2024. So while he still assigns cases to donors at a slightly higher rate than random chance, his numbers suggest a much more balanced approach compared to other judges. So this comparison highlights an important takeaway, I think. Not all judges rely on attorney donors to the same extent, and some appear to be making an effort to reduce the influence of campaign contributions on case appointments. Before we wrap up, I just want to take a quick look at the About page. And this is just a good section to go to that provides important context, much of which we mentioned today, about the project, about the research behind it, about TCJE, as well as the methodology that we used to match the different data sets and analyze the data. So this dashboard, highlights how indigent defense appointments are made, how campaign contributions influence judicial decisions, and how different judges vary in their approach. But the big question now is what can be done about this? And with that, I'm going to turn back to Jeff to walk through some policy recommendations and potential reforms.
Thank you, David. So, this is a problem that can be addressed. The current method of assigning counsel lacks meaningful oversight, which creates both the potential for and the appearance of corruption. While judges can self-regulate, we shouldn't rely solely on individual ethics to ensure the integrity of the whole system. So we're thinking about two possible remedies, and we'd encourage you, if you live in Harris County, to write to your local county commissioner to ask for something like this or ask their opinion on this. One is developing and implementing a strategic plan for the expansion of the Harris County Public Defender's Office. As we mentioned before, the Public Defender's Office really only reaches about 15% of indigent felony defendants, whereas the other 85% is covered by this appointed counsel process. The Public Defender's Office needs a strategic plan in order to hire more attorneys and cover more cases. And so this seems like a good step for the office. The second is trying to innovate and expand the reach of the Managed Assigned Counsel program. This is the program that automatically assigns counsel randomly for misdemeanor offenses. In other cities in Texas, the reach of the MAC has reached into juvenile offenses, family offenses, low-level felonies, quote unquote, like fentanyl offenses, state jail felonies. So there is opportunity here for using some of the programs that we already have to lessen the overall reach of this judge assigned counsel system. But in the absence of a complete system overhaul, we need more oversight mechanisms. First, we need to make attorney contributions more readily accessible to the public and researchers. If you know me, I talk a lot about open data. That's what we're talking about here. Campaign contribution information shouldn't just be available as PDFs or basic downloads, but in a structured, machine-readable format that can facilitate meaningful analysis. That means that we're not hunting and pecking and pulling information out of court documents. We're getting clean data sets that allow journalists, researchers, concerned citizens to easily connect the dots between donations and case assignments. We would also recommend requiring defense attorneys to disclose their unique attorney ID numbers when making political contributions to judicial campaigns. As David mentioned, there's different ways of spelling, there's different honorifics. This simple step would dramatically improve our ability to track the relationship between donations and appointments, and it eliminates that ambiguity caused by common names or inconsistent reporting. And then second, we need systematic tracking of judicial appointment patterns. Courts should be able to analyze and publish case assignment trends on a monthly or quarterly basis with a regular cadence of reporting that creates a consistent record that can be monitored over time. Then Harris County can easily develop automated systems that flag unusual patterns. This is what Commissioner Ellis was calling for back in 2020. These systems would identify potential favoritism or disparities, such as when certain attorneys receive disproportionate numbers of cases from specific judges, particularly after making campaign contributions. So by implementing these transparency measures, we can create accountability without requiring a complete system overhaul. These steps would shine light on potential conflicts of interest and help restore public confidence in the fairness of our indigent defense system. So from here, thank you. Thank you for hanging with us for the last 40 minutes. We have some Q&A, and so I'm going to ask David and others here some questions. Let's see here. Some of the questions that were asked before is, do the contributions include family members of the attorneys? And David, I don't believe it does.
I think, I mean, it certainly can include that in the data, but we weren't able to sort of assign those unless the name matched. So that was some limitations there, but certainly right, as well as like sometimes it's the law firm donating in that name, and that can be that sort of gives us some. In that case, we're doing a more sort of conservative estimate here of the scale of the problem.
Awesome. If you do have questions, please feel free to put it in the Q&A. If you're asking questions that we can't answer, my apologies. We probably won't answer them, but we will have a follow-up to all attendees after the fact, and we'll address as many of these questions as we can. David, does the current data cover juvenile courts, or is it just Harris County criminal courts?
We're just looking here at the Harris County criminal courts,
Okay,
the ones
got
that
it.
these judges oversee.
Awesome. For other counties that want something like this in Texas, what would the process be for if somebody wanted to do this in Ellis County or Fort Bend County, what would they need to go through in order to do that?
Well, that's a great question. The first thing is that the donation data that we used is not just in Harris County. So it's a state data set, well, data set in quotes, a state system that you can pull PDFs for elected officials, including judges. And so pulling that data is really the first step to understand what the patterns are. The next step would be securing criminal court data from the district court in your county, and being able to make sure that it also includes information about the appointed counsel and their name, because that really is how you're going to be able to match these data sets together.
So it's a couple of conditions there. You got to make sure that you get both the Ethics Commission data and criminal court data from your county that also has a flag as to whether or not the counsel was appointed or was public defense or hired.
Yes.
Awesome. Great. Any other questions that we'd like to have from the team here? One question is, did we take into account how often the judges are appointing cases to the public defender's office?
So we don't currently on the dashboard, but we know overall that, as we said at the beginning, that about 15% of cases go to the public defender's office across in these particular types of felony cases.
Another question is that we mentioned high caseloads for the assigned defense lawyers. How does that compare to the caseloads of the public defenders? The public perception is that public defenders are massively overloaded. One thing I will say to that is that public defenders have best practices that they have to follow in terms of caseloads. So their caseloads are capped at a certain number. In this system, with no oversight, there is no cap. So therefore, some assigned attorneys might have a normal caseload, what we would call normal, and some would have not normal, like significantly higher caseloads. Another question asked is oversight seems to be a huge issue. And Sophie, this might be a question for you. Who would be most likely to quote unquote reprimand the judges for disproportionate appointments?
So I don't know about reprimanding, but I think it is important to note that judges are independent elected officials, which is in many ways a really important function of their role. And so ultimately it's the voters who decide whether to keep them in office or not. Commissioner's Court has sometimes had, a very collaborative relationship with the judges. This Indigent Defense Committee that I mentioned that Commissioner Ellis and Commissioner Briones co-chair includes judges from both the misdemeanor and felony courts as part of a collaborative effort. Sometimes Commissioner's Court has also criticized and questioned the judges, but that's not exactly the role of Commissioner's Court, and there is no official role of anyone. And I think it's come up before. It's most concerning for people who are in the system, who are accused. Where do they go when they're concerned? And there's not a clear answer for that. And I just want to take the opportunity to highlight, if you haven't read the Houston Chronicle this morning, there's a series of articles that really highlight the worst types of failures in this system, and a person named Edric Wilson, who was behind bars for 18 years without ever having a trial. This is the insufficient appointment system is one piece of this, but it goes much beyond it. But I just want to mention that because Mr. Wilson didn't have anyone to complain to or make clear what was going on for him. except really his attorneys, and that didn't work for him. And so that's a very long answer to say there isn't someone to reprimand, but it's data like this and put together in a way that's really clear to even be able to start to ask those questions publicly and in one-on-one conversations to understand what's going on, how to diagnose the problem, and then how to fix it.
That's great. Thank you, Sophie. Another question from John is, do judges possibly make appointments based on the legal specialty and expertise, such as assault? Would that make a difference in this analysis? And while I don't know the answer as to whether or not judges make appointments based on legal specialty, the dashboard can help you answer whether or not the outcomes are better. So even if judges are making appointments based on their I perceive that lawyer X versus lawyer Y is better with assault cases or better with drug cases. When you dig into the dashboard from the link that we send after this webinar, you'll be able to see whether or not the appointed counsel are getting better outcomes than the public defender's office. Nina asks, does the dashboard also provide attorney names? It does. Campaign finance contributions are public information, and so we're just using the public information that we were able to grab. Roderick asks, could it be implied that a judge shows implicit bias based on their appointments? I'm not sure that, and David, I would defer to you on this. I'm not sure that the dashboard is going, and the data that we have is going to show beyond a shadow of a doubt that a judge has bias one way or the other. There's more context to grab, but it is important signals to pay attention to. And it's important to get more information about why the numbers look the way they do. Without more evidence, it's hard to say, is this bias or is this just a matter of convenience? But one way or the other, amid this whole universe of information and cases going back and forth, it can help hone in on what to pay attention to. Erica asks, did this dashboard take into account the type of cases, i.e. not all attorneys are qualified to do capital murder?
So you can look at specific cases and look at those outcomes as well, by different case types. So that's, and again, this is really the first time people can even look at this data. And so this is really not, may not answer all the questions that you might have in a specific case or a specific courtroom. But it is a way to at least start a conversation about this topic at a more granular level than the entire system, to really be able to, like Sophie said, start the process of holding elected officials accountable for the outcomes in their courtroom. And it's hard to know without looking at the data and bringing it together.
Another question is, are there any mechanisms or institutions which enforce the ethical guidelines judges are bound to? It's a pretty broad-ranging question. I'm not sure we know the answer to that. But in terms of mechanisms to enforce the guidelines about defense attorney appointments, there are very few mechanisms to track that. And it was, in fact, a bit of a Herculean effort to pull together the data just from the Ethics Commission and the Harris County Criminal Courts in order to pull together this study. Annie asks, and this is a question for everyone, do you see the availability of this dashboard data as a means to add scrutiny to the existing system, thus resulting in substantive changes?
Or go ahead, David.
No, go ahead, Sophie.
Just gonna say, I hope so, I think is the most honest answer I can give. But again, it's not that, as Jeff was saying, this leads to more questions and where to dig deeper, not necessarily saying one thing is definitely evidence of wrongdoing, but that it highlights the systemic issues here and things that need to change, and that we can't rely on, it's not fair to rely on individual judges to change these systemic flaws, even if they're all trying to make decisions completely independent from how donations work, or even if they don't want to be involved in the appointment system, that's really the burden that they have right now. And so I think something like this shows, as Jeff was saying, how much risk there is for corruption or wrongdoing, and also the appearance of it, even if it's not occurring. And so having something that highlights it, this originally article that Jay worked on many years ago was the first wake up call from something that a lot of people thought seemed wrong, but didn't necessarily have the data. And this shows us a real time version of what's going on. So I do think that these are important steps toward change. We also need other people to pay attention and care and hold the decision makers in Harris County accountable.
Well, excellent. Well, I think that wraps up the questions that we've received. Thank you all for spending your lunch hour with us. We had about 75 attendees to this webinar, so thank you for spending your lunch with us, and thank you to everybody here for sharing your time and your expertise on this. We will send out to all attendees a link to this video and a link to the dashboard sometime within the next 24 hours. So we'll talk to you soon. Thank you.
Thank you all.